I'm the president of my co-op, that is Bay Terrace Co-op Section 1, and I'm co-president of the President's Co-op and Condo Council.
And how many residential units are in that co-op?
200 units.
Okay. You mentioned there people were interested to hear about the lawsuit that you're bringing against the city. Can you go into detail about that?
Well, sure. So the lawsuit, we are really fortunate. We have our lead attorney. He is probably the top attorney that we can have for this lawsuit. This is Randy Mastro, M-A-S-T-R-O. And Randy Mastro, this is his specialty. He brings litigation against municipalities all over the country. As a matter of fact, all over the world. I believe he's brought litigation in London, California, Florida. So he's the lead attorney on this. And we have high hopes. Right now it's gone to the court. Of course, it's been filed. It was filed quite a while ago. The city made a motion to dismiss, which is normal. That's standard procedure. And our attorneys answered that, why it shouldn't be dismissed. And right now we're just waiting for a judge to make a decision. And we're hoping that the judge will allow it to move forward.
You mentioned when you were speaking there was essentially five pillars to the legislation. Can you explain that to me?
Well, sure. So there's five separate arguments to the lawsuit. And the first argument is that Local Law 97 is preempted by state law. New York State passed the Climate Leadership and Community Protection Act, known as CLCPA, in 2019. And that law doesn't leave room for any other laws. There's nothing that can preempt that law. So that's our first. The second argument is that it's the violation of due process. So what happens when we are found in violation of Local Law 97? It goes to an administrative person. They decide what the penalties are, but they have no expertise in this, and their judgment is it's an arbitrary judgment. So that does away with our due process under law. So the third one, and this is a big one. Now the third one, it hinges on the retroactive nature of Local Law 97. And what that means is that in the past, the City of New York, they've asked us to do certain things environmentally. They've required us to do certain things. There's one large co-op in Queens. They were burning No. 6 fuel oil. It became illegal. The city told them they could no longer do that. They were good citizens. They went ahead. They converted. They got rid of the No. 6 fuel oil. Cost them millions of dollars. They had to take out a mortgage that they're still paying for right now. And now the city is turning around and saying, well, that's not really what we meant. That's not good enough. And they're making this law retroactive. So over the years, we have followed all the regulations. We followed all the statutes. Whatever the city has asked us to do, and now right in the middle, they're changing the law on us. And so that is one of the reasons why we're fighting them. The fourth argument is that it's vague and ambiguous, and that means nobody really knows what they want us to do. We have no idea what will bring us into compliance, what will force us to face penalties, and you cannot have any type of a law that's ambiguous. So that is the fourth. And the fifth argument is that Local Law 97 functions as a unauthorized tax. And what happens, all the penalties, they're talking hundreds of millions of dollars in penalties, they go into the general fund. They don't go to improve the climate, they don't go to sustainability. And what that means is that an administration, the mayor, anyone at all, they can use those funds to balance the budget. But it does nothing to promote climate change or to fix the damage that's been done. So those are the reasons for the lawsuit. Those are the reasons we brought the lawsuit, why we think it's unconstitutional. And I'd just like to say, if I may, and something that nobody ever brings up is that this entire burden falls on the shoulders of the co-op and condo community, the shareholders who live there. But nobody ever talks about the people who are really responsible for this problem. So the energy companies, the automobile manufacturers, the people who are doing the reforestation, taking down the trees, big manufacturing plants, and energy plants. As a matter of fact, these are the people, they should be paying to fix it. They created the problem. And I would suggest the place to start is with Con Ed. I mean, they're as responsible for this problem as anyone else, and at the end of the day, they're going to benefit from Local Law 97 as we convert to electric. And I'm somewhat disappointed that no council member, not one single council member, has brought that up, that the burden should be put on the people responsible.
Getting back to your lawsuit, what's the timeline on your lawsuit? When was it initially filed, and where does it stand now? And is there any way that a decision will be made to halt the new requirements going into effect in January?
The lawsuit was filed. It was close to the end of 2022, so it's been a while now, and we're just waiting for the judge to make the decision, and I would think it has to be soon, because we would want that to happen before 2024.
But could they appeal it then, and could it go on, or what?
Oh, sure, absolutely. I mean, I would be surprised if there wasn't an appeal by either side.
Okay.
Yeah.
And who is involved in that lawsuit? Who's bringing that lawsuit?
That lawsuit is I am one of the lead plaintiffs, along with my co-op, Bay Terrace Co-op Section 1.
Okay.
Bob Friedrich, along with Glen Oaks Village,
Okay.
is a plaintiff. And there is a mixed-use building in Manhattan on Maiden Lane. They are also one of the plaintiffs. The defendant is the City of New York and the Department of Buildings.
Okay.
Read our special Local Law 97 Climate series by grabbing a free copy of AM New York Metro or visit amny.com.